Hello and welcome to the Right Hand HR webinar on the top 10 tricky questions on paternity rights. Your presenter today is Judy Pearson. I am an HR advisor with Right Hand HR supporting clients nationwide. I have worked in HR for over 20 years and have experience in retail, manufacturing and hospitality. Anyway, moving on to the webinar itself. As a result of registering to view it, you will receive via email a copy of the slides and you will be able to access free advice on any queries that you may have. The aim of today's webinar is to help people to understand some of the more complex issues that arose following the Additional Paternity Leave Regulations of 2010, which came into force on the 6th of April 2011. For those not in the world of HR, paternity, maternity and adoption rights can all be a bit of a minefield. To avoid any of the pitfalls, because no employer wants to be facing proceedings for discrimination, we have produced this webinar as a guide. These top 10 tricky questions from Right Hand HR Professionals will help employers tackle the most complex issues relating to paternity rights. First of all, I'd just like to outline some of the terms which you'll see used throughout this webinar. As you can see, very much everything gets abbreviated. So OPL, Ordinary Paternity Leave, APL, Additional Paternity Leave, QW, Qualifying Week, EWC, Expected Week of Confinement, SML, Statutory Maternity Leave, SMP, Statutory Maternity Pay, MA, Maternity Allowance, SAP, Statutory Adoption Pay, OSPP, Ordinary Statutory Paternity Pay, ASPP, Additional Statutory Paternity Pay, and KIT days, Keeping in Touch days. These are all standard terms that you'll come across throughout any dealings that you have with maternity, paternity, adoption and so forth. These are standard terms that you'll come across. And it's very important that you begin to realise what they're all about. Okay, what is the difference between ordinary paternity leave and additional paternity leave? Well, ordinary paternity leave has been in existence for a number of years. It's a period of 1 or 2 consecutive weeks. And basically it's to allow an eligible employee to care for his or her baby or support the mother following the birth / adoption of a child. Additional paternity leave is for a minimum of 2 weeks and a maximum of 26 weeks and is to be taken any time from 20 weeks after the child is born, but it must have finished by the child's first birthday. In the case of adoption, it can start any time between 20 weeks and 52 weeks after the date the child is placed with the adopter, or the date the child enters the UK if adopting from abroad. This is a further step by the government to establish more family-friendly situations and to encourage a greater sharing of parental responsibility between the parents. Is the eligibility the same for an employee to qualify for both types of paternity leave? Well, the answer is yes and no. An employee is eligible for paternity leave if he or she has or expects to have responsibility for their baby's upbringing and is either the biological father of the baby or the mother's husband or partner. Could be the child's adopter or husband or partner of the child's adopter. For the purpose of deciding if someone is eligible for paternity leave, a partner is someone who is considered to live with the mother of the baby in an enduring family relationship, but is not an immediate relative. This may therefore include a female partner in a same-sex couple. Throughout this webinar, where reference is made to he, him or father, such references should be taken to include those female same-sex partners who qualify. In addition to the above, an employee must have worked continuously for the company for at least 26 weeks by either the end of the qualifying week, And the qualifying week is the 15th week before the expected week of confinement. So in other words, the week the baby's due to be born, you go back 15 weeks from there, and that's the qualifying week. Or the end of the week they are notified they have been matched with a child in the case of adoption, or the date their child enters Great Britain if adopting from overseas. In order to make a claim for statutory paternity pay, an employee must also have average weekly earnings at or above the lower earnings limit, which applies at the end of the qualifying week. The current rates effective from the 6th of April 2011 for the lower earnings limit is £102. This is the lower earnings threshold for the purpose of national insurance, and this figure gets reviewed and updated by the government every year on the 6th of April. Statutory paternity pay is the same as the standard rate of statutory maternity pay, and as such is set by the government each year in April. The current rates effective from the 3rd of April 2011 for statutory paternity pay and statutory maternity pay is £128.73. And it's the same for maternity, paternity and adoption pay. The statutory rate is the same for each of those payments. So as well as the eligibility outlined previously, to qualify for the additional paternity leave, the child's mother or adopter must have been entitled to one or more of the following. So statutory maternity leave, statutory maternity pay, maternity allowance, statutory adoption leave, or statutory adoption pay. And must have returned to work and ceased claiming any relevant payment. Note, periods of annual leave, sick leave or parental leave which directly follow a period of maternity or adoption leave would not count as a return to work. They really do have to have returned to work and started working again. If an employee has two part-time jobs with different employers, can he go on paternity leave from both his jobs if he matches the eligibility criteria? Well, yes, again, the answer is yes and no. If the employee has two jobs and he meets the eligibility criteria for both of those jobs, he can take ordinary paternity leave and receive ordinary statutory paternity pay from both roles. He can choose to take both periods of ordinary paternity leave at the same time, or he can choose to stagger those, and as long as he takes them within the specified period, that's totally fine. In order to go on additional paternity leave and receive additional statutory paternity pay, there is the additional factor that the mother of the child has to return to work and forfeit part of her statutory maternity leave and statutory maternity pay, or adoption if it was a case of adoption. And she must sign the declaration confirming that this is the only application for additional statutory paternity pay for this child. So in other words, the answer to the question is yes, they can do it from two employers in the case of ordinary paternity leave. However, when it comes to additional paternity leave, the eligibility is only for one. Right. Can an employee break up their paternity leave and take it in blocks of, say, for example, 4 weeks at a time? Well, the only blocks of time off under the paternity leave regulations are the two kinds of paternity leave. So ordinary paternity leave and the additional paternity leave. The ordinary paternity leave can be taken as either 1 week or 2 consecutive weeks. It cannot be split and taken as 1 week and then a further week at a later stage. It is either 1 or 2 weeks together, but that's it, it cannot be broken down. Additional paternity leave can be taken as a minimum amount of 2 weeks and a maximum amount of 26 weeks. Again, however, it cannot be split. For example, an employee cannot take 4 weeks of additional paternity leave and then return for a few weeks and then take another 4 weeks. Once an employee has returned from a period of additional paternity leave, whatever length of time they've taken, once they return, they have then forfeit the right of any further entitlement. And note, if an employee opts for a long period of paternity leave, but after a few weeks decides he would rather be back at work, his wife or partner cannot then revert back to her maternity leave. By returning to work initially, she has forfeited her right to any further maternity or adoption entitlement. Basically, it is up to an employee and their partner to review their personal circumstances and their finances and decide what works best for them regarding who should stay at home with the baby or child and who should return to work. This will be influenced by who is the main breadwinner, and also if either of them work for a company who offer enhanced payments for maternity, paternity, adoption payments above statutory entitlement. Can an eligible employee take paternity leave at the same time as the mother of the child is taking maternity leave? Well, yet again, the answer is yes and no. Ordinary paternity leave is designed to be taken in the early stages following the birth, and is to care for the baby or the child and is to support the mother. So the employee will be on his ordinary paternity leave at the same time that the mother is on her maternity or adoption leave. Additional paternity leave is totally separate from the above, and a key criteria for an employee being eligible to take it is the fact that the mother of the child has returned to work. Note, under the element of paid additional paternity leave, the additional statutory paternity pay is the remaining weeks of what the mother would have received if she had remained on her maternity or adoption leave. She must return to her job to release that payment. Any attempt for both partners to claim at the same time will be deemed as fraud and will be a very serious matter. So, for example, if the father is taking 12 weeks additional paternity leave and the mother has already taken 30 weeks of her statutory payment, then returns to work, there would be 9 weeks left over. So the father could take 9 weeks additional statutory paternity pay, and the remaining 3 weeks of his 12 weeks would be unpaid paternity leave. Does an employee on paternity leave have any special rights during a redundancy situation?